What's up, everybody? Welcome back into another episode of The Lawyer You Know. Good morning. It's Saturday. It's the weekend. Hope everybody is having a wonderful day so far. And I'm glad you've decided to start your Saturday here with me to talk about ARCCA. Very, very important witness. Dr. Wolf takes the stand. We remember him from trial number one. Very different testimony. Once again, trial number two. And we said this before trial two ever started, that it's going to be similar. Like, the same witnesses may testify, but we think it's going to look very different. And boy, was that correct, because this was incredibly different. He did so many different demonstrations and experiments, and we're going to be able to look at the testing and what does it show. But is it all good for the defense? I've seen so many comments online saying that his testing actually proves the Commonwealth's theory. And maybe that's why the Commonwealth's experts did not do these tests. But it's very important to look at these tests and experiments the appropriate way and see how the lawyers are going to be able to explain them. And the most important thing might be, we're not done yet. We're close, but we're not done yet with the defense's case in chief. So make sure you get your questions ready. Let's get into it. So I want to focus on and talk a lot today about the testing that he did, and show you kind of the different testing, and as a lawyer, how you argue it, why you're asking certain questions, why you're building, because it seems like, oh man, this seems repetitive. He's asking the same questions. It seems like the same testing. Why did they do it in these three different steps? So we'll talk about that as well. And I think all of that is really important, because some questions that were asked on cross that were some pretty good points made by Brennan. If you remember direct, it's like, that's not really how it came out. And Brennan tried to do that a few times, where he would ask a question in a certain order to make it seem like it went with the questions that came before his most recent question, but it actually didn't. And he was trying to really use the timing of it to mislead the jury in certain areas, at least the way that I felt, listening to some of his questions and watching the cross. We're not going to talk a ton about Dr. Wolf's education experience. He did mention DOJ and NHL, and I will just tell you. So Brennan kind of brings that out on cross, like, you mentioned DOJ and NHL. Why did you mention those clients? And Wolf admitted those are some of the high-profile clients, and I guess that he didn't work with the DOJ when they had that contract. So I thought that was a good point by Brennan to bring up. You're trying to bring up the exciting clients, and I will tell you what plays really well here. I get why the NHL is going to play really well in Boston. What plays really well here is NFL and college sports. So we have a lot of experts in our world. It's orthopedics, and so we have a lot of people that work with local teams like the Bucks, Florida State, Florida, USF, whoever it might be. So a lot of times we try to bring that out, because jurors love sports and doctors that work on sports, and they think, oh, the Bucks would never hire this doctor if he wasn't good. So that's why you bring things like that. But Brennan did a good job saying, you work for lawyers and insurance companies too, right? And he's like, yes, I do. And I thought that was fair. And I thought that was a good point by Brennan. The problem is Brennan followed it up with questions about being hired on this case to absolutely, in my opinion, try to get the jury to infer that Wolf was hired by the insurance company. Jackson deals with that on redirect, but we're not going to go a ton into his background and experience right now. We've heard it last trial. We know they're the type of experts that are always hired in cases like this, especially car accident cases, trucking cases, cases dealing with the way people's body moves, what cars do, accident reconstructionists. These are the guys you think of, the guys from ARCCA, in my opinion. Somebody said the Milwaukee Bucks. I meant the Tampa Bay Bucks. I'm in Florida. They look at the case independently. They were hired by an independent third party. And Brennan objected to a bunch of these questions, right? And this is all before cross, where he tries to slip in the insurance stuff. But they object to this, and Judge Cannoni sustains it. And I'm like, what are we doing? Like, I get we can't say FBI, but why are they not letting him say independent third party? They have a sidebar. I don't know what happens, because Jackson kind of moves on. But they, after all the discussion with my dad, with some other lawyers, are they going to ask these questions? Are they not? I always thought they would. I always thought they should. A lot of people disagreed with me. They wanted to. They absolutely wanted to get into the fact that they came into this case. They did the initial testing when they were independent and unbiased, and then speak about very clearly when they engaged with the defense. And that's exactly what Alan Jackson did And I thought that was the absolute right move, again, to differentiate them from a lot of the other experts in this case. But even though Cannoni tried to keep some of it out, multiple times Jackson would slip in, and even Brennan did, saying, you were hired by some other agency. Some other agency hired you, and Jackson confirmed on redirect it was not an insurance company, but an agency. And if you remember, that's a lot of the same verbiage used in the people questioning Jen McCabe, etc. So will the jury put it together? I think it was much more obvious this trial that agency might be the FBI versus trial number one, but they didn't come out and say it. So what will the jury think? We're not so sure. All right. So the first kind of chunk of testimony we're going to listen to a bunch of chunks. We're going to skip through some of the testing, explain it. But the first chunk of testimony is talking about kind of what you expect in different accidents like this and what you saw in this case.
Also on the wraparound section of the bumper cover, as it's going from the rear to the right side, there were some superficial scrapes in that area.
Did you note any other damage or deformation to the Lexus? Deformation in the tail, the lift gate, the bumper, anything like that?
No.
Is it common in a vehicle pedestrian collision that there is some sort of bumper deformation that's associated with a vehicle pedestrian incident?
That can certainly occur if a pedestrian is in an normal upright position. You can certainly get displacement of the bumper.
Did you see any displacement or panel deformation on the Lexus?
No.
Is it more common that there's panel displacement or deformation if the collision is above, say, 10 or 15 miles an hour?
Yes.
During your review of all the investigative materials, did you note any items of evidence that were recovered or claimed to have been recovered on the bumper itself?
I recall there were 2 or 3 apparent glass fragments.
What's the significance of that? Let me ask it differently. Is there any glass in the taillight assembly?
Can you repeat that question?
May I ask that again?
Yes.
Is there any glass in the taillight assembly?
No.
Was there any shadow?
And that's important, right? That's important because we are going to get into what is in this taillight, which is incredibly important. And I learned a lot, right? It's like certain things you know, but once he explains them in detail, you learn a lot more because of them. But the fact that there is no glass and Brennan didn't hit that at all on cross, that creates even more of a suspicion with Proctor and the glass on the bumper only matching what he found. Let me see it. Okay, now I got closed caption.
Shattered glass anywhere on the Lexus, meaning panes of glass, the back window, quarter panel windows, anything like that?
No.
Did you have any understanding at that time of what the Commonwealth's theory of the case was when you began your initial analysis?
Sustained.
Did you have any indication of what the Massachusetts State Police theory of the case was based on the investigative reports that you had received?
Sustained.
What's funny is Jackson does a good job. Both of them are going to get in what they want to get in, right? Brennan and Jackson. So Jackson's trying to do it the right way. Objection sustained. And then he just starts asking about their theory.
You perform an accident reconstruction analysis to determine whether or not the damage to the Lexus, that taillight housing material, was consistent with an interaction with a pedestrian.
Yes.
Specifically, did you perform?
That was, in fact, their theory that the Commonwealth would not let the ARCCA witness answer.
An accident reconstruction to determine whether the damage to the Lexus was consistent with an interaction with John O'Keefe based on the injuries that you were aware of?
Yes.
Did you evaluate whether the investigative theories regarding, let me ask it a different way. Did you consider the possibility of Mr. O'Keefe's head striking the taillight?
Yes.
Did you consider the possibility of Mr. O'Keefe's arm striking the taillight?
Yes.
Did you entertain the possibility that Mr. O'Keefe's center of mass, his body, struck the taillight?
Yes.
Before we get into the initial testing, were you able to come to opinions and conclusions concerning those things that I just mentioned?
Yes.
Did you also entertain the possibility that a drinking glass could have damaged the taillight?
Yes.
Were these some of the things that you were sort of left open to you to decide yourself?
Yes.
Did you later provide all of those opinions and conclusions in a report to the entity that hired you?
Yes.
And your understanding that those reports were then later supplied to both sides here in this case?
That was my understanding. Yes.
And if you listen, I mean, I can understand why the first jury thought it was an insurance company, because an insurance company would do something like that. And if both sides wanted it, they'd be provided it. But Jackson did a good job this time. And again, learning from trial number one, learning from you, the chat, learning from the jury interviews, make sure they know it's not an insurance company. So now that doesn't leave a lot of options of who that could be. Maybe the court, maybe they could think the judge hired them at first, which again would be good for the defense when they're the ones that ended up hiring them, but definitely not an insurance company.
Did you testify about those initial testing opinions and conclusions at a proceeding last year?
Yes.
Let's talk for a second about that initial testing that you conducted in connection with this case. When approximately did you begin your testing? And I'm going to phrase it as your initial testing, the testing that you testified to about last year. When did you start that initial testing?
From what I recall, it would have been late 2023.
So I'm going to jump ahead just a little bit to the actual test. So this at this point, they're basically trying to prove the drinking glass didn't cause the damage with this test we're going to watch first. But I also thought, so this is something else. So he really made me think. Dr. Wolf really made me think. He talked about so many different scenarios. And I thought they were really good building on each other, opening up the different possibilities. And when I was thinking about all this, and from the last trial, I was like, why are they even trying to say the drinking glass did the damage? Nobody's trying to say that. The Commonwealth's not saying that. I think it's because of where the glass ended up, why nobody's actually saying that. But if I'm actually trying to determine how the taillight would have caused the scratches on John O'Keefe's arm, it never made sense to me that it would explode into 47 pieces and cause the scratches at the same time. But it actually might be more plausible. And just hang with me. Tell me if you disagree, right? I want to hear if you disagree. If John O'Keefe was mad, did throw the drinking glass, it smashes the taillight first, then it backs up, scratches him as it hits him, knocks him over, and he falls on his head, and then she leaves. That, to me, as far as the scratches go, it still doesn't make sense as far as if you're going 24 miles an hour and you hit somebody, what would the injuries be, et cetera, et cetera. But as far as how you get the scratches, that makes way more sense to me than the taillight exploding as it's hitting him and scratching him at the same time, which feels next to impossible at this point. So to disprove that it was the drinking glass, I think was necessary. But as far as the Commonwealth goes, it's like that glass on the bumper doesn't help you because it doesn't match the taillight. The glass location of where it was in the yard doesn't help you because if he threw it at the car, there's a very low chance it would end up right next to it where it ended up, right? So I thought that was interesting, just the way he explained it. I was like, yeah, I guess that would kind of make more sense for the scratches, even though it still doesn't make sense. But Welcher explaining that, it could have hit him right here can line up with that as well. Natalie said too much watching the SUV hit John in the arm, the test dummy in the arm. I fear the jury is going to see it as possible. So this is kind of a good opener into this testing. And this is why I still think that the Commonwealth should have done these tests, even if to say this is not exactly how it happened, but we wanted to show you that an arm can break a taillight. It doesn't always break it the same way. It's different damage every time, depending on exactly where the arm positioning was. But there are some theories out there that an arm can't break a taillight. And we've talked about those theories on this channel. And I wanted Welcher and Rentschler. I mean, could they get any closer? We've had two wolves. Welcher didn't even do that. And I thought that was a huge and very impactful part of the direct, that they just didn't even ask Welcher. Welcher didn't even give them these answers. It doesn't have to be perfect to do exactly what Natalie said. Prove to us an arm can smash a taillight. Okay, check that box. Now prove to us it can happen without breaking the arm, right? Which is step 2 that hasn't happened yet. But they didn't do it. And instead on cross, Brennan wanted to make it sound like this proves nothing. So Natalie, I don't really know if Brennan even tried to go that route. I would have been like, hey, the arm broke the taillight, right? Okay, you say it didn't break the diffuser, et cetera, but it broke the taillight, right? We can all agree there. It didn't shatter exactly the same way. And then you go into the fact that, of course, it's going to be different every single time, depending on when it hits. But they didn't do that. And that's something that doesn't get lost for me in this direct. I hope it doesn't get lost for you either, because the Commonwealth just didn't do it. They didn't do the testing. And yes, we're going to talk about the 400,000 versus 50,000. It's definitely more than 50,000, the totality of their testing, but we'll get into how that helps the defense. But they just didn't do it. That's the problem. And when you don't do it as the Commonwealth with the entire burden of proof, you don't get the benefit of acting like this is something that you proved, usually to a jury. We'll see if that's how it ends up. All right, let's listen to some of the first sets of testing.
Is this the photograph that was just marked as Exhibit 213 that's in front of you?
Yes.
Can you explain to the jurors what they're looking at?
So on the left part, you are looking at a frame from the high-speed video just after the contact with the taillight. On the right, you're looking at the post-damage to the taillight after the glass had been fired into it.
And if we could look at the next exhibit with the course permission.
Okay.
And what are we looking at here?
Same thing on the left. Again, this is the 37-mile-an-hour test. The glass striking just in the area where the bottom of the turn signal indicator is, so right where it meets the red portion of the lens and the clear portion of the lens. That's about where the impact point was. You could see that a large portion of the outer red assembly, lens cover is missing and fractured. The clear portion of the part of the outer lens to the turn signal indicator is also fractured, as well as the underlying clear diffusers in that assembly.
Would your testing in both of these scenarios, the 31-mile-an-hour test and the 37-mile-an-hour test, represent an accepted methodology for controlling for aim, velocity, impact site, and those issues, if you will, as it relates to testing of this sort?
Yes, we were able to control those variables.
And is that an accepted methodology in the area or the field of accident reconstruction?
Absolutely, yes.
When you finished your testing, were you able to make a determination as to whether or not either one of these velocities, the 31-mile-an-hour velocity or the 37-mile-an-hour velocity, were consistent with the damage that you saw on the subject Lexus, which is the 2021 Lexus belonging to Ms. Reed?
Yes, from the 37-mile-per-hour test, we are getting damage that's generally consistent. And that I mentioned, we have portions of the outer lens missing, the underlying diffuser. There was also some fracturing on the backside of the assembly. So again, we observed damage that was generally consistent with that of the subject taillight.
And that was the 31 or the 37?
The 37.
37. What about the 31?
Didn't have enough energy to create that damage.
So were you able to conclude, in your opinion, whether or not the velocity of that glass hitting the taillight would have to be somewhere in the vicinity of 37 miles an hour, well above 30 miles an hour?
Well above it. It certainly could have been above 40 miles per hour per se. I mean, we may have actually blown out more of the outer lens had the speed increased.
So basically he's saying to get damage consistent with what happened to Karen Reed's taillight, that drinking glass would have had to been traveling. It's a hard glass drinking glass, would have had to been traveling at 37 miles an hour or faster. Which again, the Commonwealth isn't even really bringing as a theory, but I think it was good for the defense to lay the foundation of just how difficult it is to break that diffuser. Because he was like, there's the taillight plastic, then there's some space in between, then there's the diffuser. And in Karen Reed's Lexus, all of that was smashed through to the tune of 47 pieces or whatever. And that's why you had clear, that's why you had red, that's why you had a little bit different material. He is the first person to explain all of that to us with how the taillight is made and how it's all set up and the material in it. So I thought that was a very good point to go through this exercise, even though the Commonwealth's not even saying that it was from the drinking glass, because that's actually a more plausible theory, if you can believe it. The Mrs. Starr, happy 4-year anniversary to my husband, Dustin. Congratulations. Lawyer, with Brennan snark at witnesses who didn't earn it, does it make the lawyer look bad or the witnesses? His MO towards every witness is getting old. So I like to ask you guys about that, the chat, and tell me what you think. I think a lot of people kind of hate Brennan or kind of against him at this point, which maybe the jury is too as time goes on. But from my perspective, I always say this with aggressive lawyers and bulldog type lawyers, it can go really well or it can go really poorly, depending on how a jury sees you. And he can absolutely lose effectiveness because of his demeanor. So lawyers can ask really good questions and it can lose the effectiveness if the jury just doesn't like the way they're asking the questions. Hannah, probably a stupid question. I doubt it. Can the defense do a rebuttal as well? Good morning from Ohio. You're literally the #1 lawyer, YouTuber, in my opinion. Thank you so much. So this is funny. I don't want to get too into it because there's a podcast that may or may not be dropping tomorrow night with my dad, where we talk about this. And we talk about what scenarios the defense could have a surrebuttal after the prosecution's rebuttal that's different in this case because she's going to allow Welcher to testify to more than he would be limited to in a normal rebuttal. Points from defense cross of Commonwealth's experts: 1, Meadows, camera angle, Bosch, black box, wrong trip, final defense witness to clear all this up. I don't think I don't think they're going to have a witness that's going to specifically hit these points. I could be wrong, though. Can the defense cross on that last rebuttal? Oh, the one that's happening right now where we stopped the day? Yes, my guess is the judge is going to let Brennan do another cross. Happy Saturday, Lawyer You Know fam. Peter, do you think the defense will call in the remaining days? Are Proctor and Higgins out in your opinion? Thanks for all you do and have a great weekend. I do think they're out. I think the missing witness instruction kind of indicates that to us. From what I've heard, here are the reports. I heard they're not going to call Richard Green, which I tend to agree with. I don't think he was overly effective. I think all that's kind of confusing, and I think they mucked it up enough with the Commonwealth experts. I've heard they're going to call Rentschler, who is Wolf's counterpart, and we're going to focus a lot on what we think he's going to testify to in today's video. And I think they're going to call their ME, who's going to talk about the injuries some more, and they're really going to finish strong with the injuries. Kelly, 100% of objections by Hank were sustained of 40. 22 of the 24 defense objections overruled. So frustrating. I totally get that. I think those numbers are crazy. I can't believe that that's what's happening. But I will say, just like Hank Brennan struggled sometimes on direct, where he was leading witnesses, Alan Jackson does the same thing. And a lot of those are, you're leading a witness on direct examination, and she just wants him to rephrase it. And that's just how it happens. So a lot of those are that, but I agree, those numbers don't lie. And that's a problem. It's kind of like when you see an NBA game and one team has 87 free throws and the other one has 2. It's like, that's a problem. That's a problem. Kellyanne said, Peter, I work for an insurance company and we only hire people like ARCCA when the story and damage don't match. In this case, we have hired them. So I understand getting that out there. Absolutely. And we only hire them when there's an issue there too, right? And there's a liability issue. And how did this accident happen? Or how did the accident cause the injuries inside the car? How's the person's body moving? Things like that. Not in just a damages only case, but this Kellyanne, you should know this part of the trial, right? Reminds you a lot of the work that we do, right? In these car accident, truck accident, these wrongful death cases. This is what the testimony sounds like, a lot more than your average homicide case. All right. Then we get into the other testing. I'm just going to talk about, kind of skip over who hired him. We already talked about that. He asked him when Welcher wore the same clothes, which, by the way, I'm wondering now if Dr. Welcher knew that ARCCA used the same clothes or similar clothes, I should say, to what John O'Keefe wore that night. And that's why he dressed up like John O'Keefe to do his experiments. I don't know if that's true or false, but Alan Jackson, and I think this came from you guys, the chat, how weird it was, creepy. Why did he do it? Unnecessary. Why would Welcher dress up like John O'Keefe? It proved nothing. Alan Jackson took those exact questions from online, or he thought of them himself, of course. But the same questions you guys had, and he asked Dr. Wolf, was there any reason for that? Did that add anything to his testing? Absolutely not. It was irrelevant. It didn't change his testing at all. So then why did you, Dr. Wolf, put your test crash dummies in some similar clothing to what John O'Keefe was wearing? This time there was an actual reason, because he wanted to see, he was doing actual impact dynamic testing. He wanted to see how the clothes react to the dynamic testing. And Brennan made some good points about this on cross. But I wanted to bring that up now before we see the first set of testing, then second set, third set, to show how it was less effective if you remember how they set up the testing. And again, Jackson dealt with it beautifully on redirect, but it was some good points on cross as well. So let's get into some of this testing.
Appears to be an orange t-shirt.
Is that similar to what was described as?
All right, before we get into their next set of testing, he's going to talk about some of the shortcomings with Welcher's testing, which is important because this is the this is the burden of the Commonwealth, and this is where they fell short, according to what Wolf did.
Being, as John O'Keefe having worn that night on January 29th, 2022?
Yes.
Is there any significance to wearing that t-shirt?
Not that I can think of, no.
Did you note any or identify any shortcomings with this particular test?
Well, much like the static test, again, it leaves the door open to all those questions, right? About again, doing this at 2 miles an hour doesn't tell you anything about, well, what happens at 10? What happens at 15? What happens at 20, right? In terms of what are the collision forces? What's the damage? How does the arm move? What would the expected injuries be, right? This dynamic test, as well as the static test, doesn't answer any of those questions for us.
Is this test from Dr. Welcher considered a force calculation?
I'm not aware of him making any type of force calculations or measuring accelerations or anything of that nature, no.
Did Dr. Welcher conduct any testing to determine whether the damage to Ms. Reed's Lexus was consistent with the striking of an arm of a pedestrian?
I'm not aware of any impact testing that he did, no.
Did Dr. Welcher conduct any testing to determine the forces necessary to cause the damage to the taillight of Ms. Reed's vehicle?
Not that I'm aware of, no.
Did Dr. Welcher conduct any testing to determine the forces necessary to cause the injuries to John O'Keefe's arm?
No, not that I'm aware of.
Did Dr. Welcher provide any opinions as it relates to the speed of the subject Lexus at the time of the alleged incident?
No, from reviewing his report and his PowerPoint and analysis, I could not find anywhere in it a specified speed or even a range of speeds.
Did Dr. Welcher provide any opinion as it relates to the forces experienced by the taillight in such an impact?
Not that I'm aware of, no.
Did Dr. Welcher provide any opinion at all as it relates to the post-impact trajectory or movement, if you will, of John O'Keefe's mass or his body subsequent to the alleged conduct?
No, not that I'm aware of.
Next slide, please.
A lot of no's there. And that's kind of what if I was the Commonwealth, I would have absolutely had Welcher done that. And I will tell you, the defense would have ripped him a new one on cross. They would have been like, oh, you don't know where the arm was. You don't know this. You don't know that. This would change that. They would have absolutely done that on cross. And guess what? You just eat that because that's not the point of the testing. The point of the testing is to show this is how fast it takes for the arm to break the taillight. And guess what? If it's anywhere around 24 miles an hour, that's great. This is the force it takes to, shatter his arm. It wasn't going that fast. It had to be fast. Whatever it was, do the testing, show what it shows. Now, it's all bad for you, and that's why you didn't do it. Well, we shouldn't be here. But to just not do it at all, I think maybe because you're afraid of what the testing is going to show, and your reason for not doing it at all is, well, there's too many variables, so we didn't even want to test any of that. And ARCCA is going to prove there's not too many variables. NOLA said, I lean completely not guilty, but I found myself wondering if the ARCCA testing didn't show that in some way it was possible that John was hit by a car. This is a common sentiment and common theme. And I think you're right. It showed me that an arm can shatter the taillight, but we have to remember they're not done. Because Rentschler, the other ARCCA witness, we're going to see this arm flying around on this crash dummy, doing 360s, all sorts of stuff. So let's wait because we know now what it takes for the arm to break the outer layer of the taillight. Just remember, none of their testing does the arm break the diffuser, the second layer of that taillight. None of it, which is what happened to Karen Reed's Lexus. So it falls short on that detail. And details are incredibly important here. Will the jury get into the details or will they just say, oh, look, looks like it's possible. They even showed us what it could look like. Guilty? Could happen. It's not how it should happen based on the testing and the testimony. But I agree with people that are seeing that ARCCA actually showed us possible, which is what Welcher should have done, in my opinion. But we haven't heard what would happen to a human arm if we get it to that level, to what it took to break the outside of that taillight. So wait to come to your final conclusion until we hear from Rentschler, because I think that's going to be a big focus on his testimony. Have you seen lawyers ask the same question over and over again until they get the answer they want? Or is it just certain lawyer style, you think? It's certain lawyer style. Usually you want to, if it's really important, you stick to it and you don't just let it go. But usually you want to change a little bit the way you're asking it, especially if it's coming over an objection. Who do you think the Commonwealth will call / recall for rebuttal? I think they're going to call their dog bite expert and Welcher for sure. I'm not sure if they're going to call anybody else, but I think for sure those two. All right, let me see here. So Jackson, something I really liked about what Jackson did, and again, I like to try to do this different than Alessi, who's very smart. We all know he's very smart the way he asks the questions. I feel like Jackson likes to play dumb a little bit. Explain this to me like I'm in 6th grade. Explain this to me so that it's so easy. Keep asking it. Keep pushing on that. Explain it to me simply so that we're positive the jury is with us. The jury, everybody on the jury understands, and then we can move over to the next step. I felt like he did that multiple times with Wolf, and I think it helped them a lot. And to me, as Wolf explained the dynamics and how things moved and why it's so important, it shows how woefully short Welcher's testing was, or the lack thereof. That was the biggest thing here, is the dichotomy between Wolf and Welcher. And how can you possibly think Welcher is worth his salt when he just decided not to do any of these testing that ARCCA showed is very doable? Very, very doable. Now, can Brennan pull some good stuff from this? Absolutely. I think he will, and I think he should, as the Commonwealth. If there's something that feeds into your theory of the case, go for it. And that's what he did. But let's take a look at the first set of testing here, which was done. I think he said, I think I put in the setup too. If I didn't, I'll explain to you which one's which.
What is this SUV that we're looking at? We actually have access to this truck.
We have access to that vehicle, yes.
And ultimately, what testing did you undertake specifically as it relates to this particular vehicle?
We did full-scale vehicle testing with the vehicle driving into an ATD arm, as well as an ATD arm attached to a dummy, and then a full-on impact to a test dummy.
So those are the three tests they do. And we're going to watch parts of all three of them. An arm attached to a dummy, and then a full test dummy. Rainey, this is a good point, right? You show the good with the bad. You show the good with the bad, because even though the taillight broke, the defense is like, still clearly it couldn't have happened the way that this happened. They're not saying it's impossible to break the taillight. They're saying it's virtually impossible that it didn't happen the way they're saying it happened. And they not only didn't hide that, but there are rips in the clothing they didn't hide. And we're going to get to how that turned out as well. Another point, I thought Brennan made a very good point, that got smashed later. Peter, go get a new Rolly to celebrate 500K subs. I like the way you think, Eli.
Did you assess the damage to the right tail light after these various tests?
Yes, after all of the tests.
Did you assess the acceleration and quantify the forces that were involved?
Yes.
Did you assess the material and textile damage to the clothed ATD?
Yes.
Ultimately, did you conduct lab tests in an effort to answer some of these questions as well?
Yes.
The ATD is the crash test dummy, just so everybody knows, so that if they use that verbiage, hopefully nobody gets confused if you jump in kind of later in the video.
And you've already mentioned this, but you utilized in your testing the exemplar vehicle to the fullest extent that you felt necessary?
Absolutely,
Were you
yes.
hampered or hindered in any way in terms of damaging the vehicle or utilizing the vehicle in any way that you wished?
No.
Let's go to the next slide, please. What are tests A and B? What are those laboratory tests?
So these were the...
Before we get to those tests, Forrest Dump said, Bev is corrupt, lifelong public defender as a lawyer, bottom of the barrel cases, her father ex-DA got her, political donors got her a bench job, main speaker at her, I can't tell what that says, sorry, it's so small on my screen, was Cosgrove, special prosecutor against Turtle Boy. Does it say apt appointment? I can't read what that says. So I'm at this criminal defense lawyer, Florida Association of Criminal Defense Lawyer conference this weekend, and we played golf yesterday with a couple of the lawyers, and we were talking a little bit about some of these cases. And one of them actually had lunch with Daniel Rashbaum last week, and he was telling me about that. It was kind of funny, just talking about the Adelson case a little bit. But they were saying that their feeling is lifelong public defenders make worse judges. Somehow they're even worse on the other side than state attorneys. There's only one or two in my area that I go in front of a lot that were ex-public defenders, and I really like both of them. And some of the prosecutors are amazing, like some of my favorite judges and some of my least favorite judges. I just thought that was an interesting tip. And he'd been a lawyer for like 40 years, maybe 35 years. I think he's been a criminal defense lawyer. He was a prosecutor to start. So I thought that was an interesting take from him. He's a Miami lawyer.
Were the initial two tests that we did to get an idea of starting to test this hypothesis. As I mentioned, we weren't sure at 10 miles an hour what would happen to the taillight. We wanted to see what would happen at 17 miles an hour with the arm. So again, it was to evaluate from a starting point what happens in this interaction based upon how Dr. Welcher had his arm oriented in his PowerPoint analysis.
Next slide, please. What is this?
So you're looking at a photograph of our lab setup. You can see on the left side of that is our hybrid 3 anthropomorphic test device. To the right is a linear impactor, and this is something we already have in-house that we built years ago for our testing that we do for the National Hockey League when we're looking at, what's the accelerations on an impact to a goalie wearing a helmet, right? We'd use this same device for that type of testing to measure head acceleration. So we applied this same linear impactor to be able to project, if you will, or accelerate the taillight at a known speed into the ATD arm.
What are some of the instrumentation that you use in addition to the mechanical impactor What's some of the instrumentation you use to track the data?
Certainly. So we have an accelerometer.
I'm going to skip through some of this. They use a lot of different things to track all of this. Okay. But I'm going to skip ahead a little bit. Welcher made it seem like 24 miles an hour was random and cross. Brennan did the same thing with Wolf and cross about 24 miles an hour in the glass. Can they mention Trooper Paul's theory? I mean, I thought they would mention it with Wolf. They didn't. I just think that's even better for the defense. Like the Commonwealth is leaving it vague, leaving so many options open. I'm like, why would you want to do that as the Commonwealth? Like, what have you proved? That's what I don't get.
On the right,
Some of the mathematical
exact, is there
the data that you would receive?
It's just how they use the same clothing.
What are we looking at?
This I thought was just so A+, right? Because so many people have asked about, well, if the taillight was frozen, how cold it was outside, this or that. It's like, well, guess what? These are the types of experts that create and 3D print all these taillights. They put them in a freezer. They make sure they're at the right temperature before they pull them out and do any of their testing, which I thought they even bring a freezer with them outside when they do some of their dynamic testing with the Lexus. I mean, how chef's kiss was that?
Looking at in these photographs.
So you're looking on the left, a photograph just before the impact test was conducted. On the right, you're looking at a thermal image that is depicting the temperature profile of the taillight.
Describe that thermal image.
Certainly. Your Honor, may I refer to my notes?
Yes.
The profile of the temperature down in this area. And when we look at that segment, that lower portion here, where contact was made, the average temperature in that area was about 34 degrees with a minimum of about 33 degrees.
How did you get that exemplar taillight down to around freezing?
So all of the taillights that we tested were preconditioned overnight in a freezer.
Why was that important?
Well, it's my understanding that at the time that this allegedly occurred, the ambient temperature was 31 degrees Fahrenheit. So as I mentioned earlier, certainly there's a correlation between how plastics perform in cold weather. So we wanted to take that variable into account in our testing to precondition them down to temperatures that were consistent with at the time of the alleged incident.
Next slide, please. What are we looking at in this slide, on this photograph?
So this is a video. Do you want me to go ahead and play the video?
Tell us what we're about to see, and then I'll ask the court's permission.
So you were looking at a camera that is mounted above the entire setup. If you look at the top portion of this video, you will see the taillight. Part of it's covered by the high-speed camera. But what will happen is the linear impactor will fire, and the taillight will be accelerated up to 10 miles per hour, striking the clothed ATD arm.
What's the court's permission?
Okay.
Let's go ahead and play the video. Next slide, please. What is this?
So this is also a video, but with the high-speed camera. So it's the high-speed camera that's looking top down at the arm. So you will see when the video plays, you will see the taillight enter from the left and contact the arm. And I will note that this is essentially slow mode, so it's not happening in real time. So you'll see the taillight slowly moving, but it's actually in reality moving at 10 miles per hour.
Understood. Go ahead and play that. Can I ask a question now that that's played? How did you mount the taillight to the accelerator, the linear accelerator?
Right. So we had to get a little bit creative there because you may have observed this when we had the physical assembly out earlier. The back of that, it's not some nice clean surface that we can just bolt on. So what we had to do is 3D print a bracket that we could bolt onto the linear impactor. And we used a polyurethane expanding foam to be able to marry those two together so that we could then bolt it onto the linear impactor to use it for this test.
Did you see any debris from that foam mounting mechanism?
Yes, there's a few flakes you can see of that polyurethane foam off the backside kind of going into being dispersed there.
Okay. With regard to this particular 10-mile-an-hour test, what did you note in terms of the damage to the taillight?
It was very minimal.
And what did you note in terms of any damage at all to the hoodie?
There was none.
We go to the next slide, please. What are we looking at in this slide?
So this is looking at a side view. So same test, just looking at it from the side. And similar, you'll see the taillight.
What did you note?
By the way, you can see the way the arm moves here. There was a question here from KWNY. As an engineer, neither side's testing is conclusive. There are too many variables to consider, including the exact angle force is applied to the specific plastic light structure on her exact vehicle. So here's what I'll say. I will completely agree with you that none of these are conclusive. But in the law, they don't need to be conclusive. They are appropriate tests to show what force is necessary to break something that is similar in kind. It does not have to be the exact same as her Lexus in order for it to meet the standard to testify before the jury. And from my perspective, I agree it's not conclusive, but it does show that the arm can break the outer layer of the taillight, which I think is important for the Commonwealth, that is possible at these speeds. But what does it not show? All these different tests, and they couldn't get the arm to break the diffuser. All these different tests, and we'll see what Rentschler says about what it would do to a human arm. To me, that is very convincing, because those are the big questions I had in this case from the jump. I think Jackson should have asked about the distance it takes to accelerate to the speeds that were tested. Will he get a chance to bring him back? So he's on redirect right now, so theoretically he could. He didn't ask. I think the reason he didn't ask is because that can probably happen in 87 feet. But the Commonwealth didn't talk about that either. There's so many things that are unknown that didn't get dove into even more, that I would think if they were really, really great for one side or the other, they would have asked more about that. Scott, I shared this case in your recaps with members of our club. Is that a golf club by any chance? And now we all watch Lawyer You Know. That's awesome. How do you think the two doctors compare, and what are the key things the jury should focus on when comparing them? To me, there's really no comparison because Wolf did all the testing. Now, if you want to take some good points for the Commonwealth from Wolf's testing, fine. But Welcher didn't really do anything. Welcher almost proved zero to me. It was just like, hey, we have somebody too. That's what it felt like to me. Now, he did prove, I guess he should prove it lined up with the arm, which on cross, Wolf testified to too. So you really didn't even need Welcher if you're the Commonwealth. But all of the testing Wolf did and the way he was able to explain it to me was 100 times more important and effective. And I think it's up to the lawyers to really point out why it's good for their side. Do you think Brennan's objections are turning the jurors off, creating doubt all on its own? I don't think so. And I mean, if it's true what somebody else posted, that all of his objections got sustained, you can't really hold it against an attorney if he's objecting to something wrong the other attorney's doing. I know people are going to say the judge is biased, but I mean, that's tough. Will the lack of trust/confidence in Hank Brennan lead to more not guilty? It's possible. The way a lawyer acts, absolutely, that can be possible. What's up, Pita? My best friend, Tasha, and I found you last year. Finally subscribed. I think you're wicked awesome. P.S. This trial makes my brain smoke. I get it. I feel you. Bobby, any update on the proposal? I just can't believe it's actually real. I think the guy did, somebody was digging into this, and I think the guy said it was real, and she said yes. So hopefully it is true, and hopefully true love is happening right now, but we'll see. And then justice for Randy. Yes, justice for Randy. I'm no scientist, but what if the car was reversing at the same time the glass was being thrown? Wouldn't that contribute to a stronger damage on the impact? Yes. You're no scientist, but that's exactly what the principles that Dr. Wolf testified to. That's exactly what I would think as well. Also, Peter, on rebuttal, can the Commonwealth call the D witness? Would you do your mock closing for both parties after the rebuttal? Probably not going to be able to do that this time. Work just happens to be really slammed at the same time this trial is going on. I don't know. Can they call the D witness? I don't know what that means. Hank Brennan asked Dr. Wolf, wouldn't you like to know the position of the body? But Welcher conceded that he didn't know the position of the body either. The point is, the Commonwealth is treating this almost like a defense attorney where they're just poking holes and saying, you can't really prove what happened because there's too many variables. Even their Dr. Walsh that they tried to use to impeach Russell said the same thing. Even their ME said undetermined. Guess what? All of that equals unproven, which equals not guilty. That's the problem.
Oh, in terms of deflection of the arm, the test arm?
Well, the arm essentially, and we'll see this in the data later, it reaches a common velocity with the taillight based upon the portion of the arm that was contacted, again, consistent with how Dr. Welcher has it oriented, it will become accelerated up to 10 miles an hour roughly.
Over approximately what period of time is that arm accelerated up to 10 miles an hour along with the taillight?
We'll see it on the data plots. I think it's about 10 milliseconds or so.
How long, do you know how long an eye blink on average takes?
Off the top of my head, no, I don't. Probably pretty quick.
Basically, what Jackson's trying to say is this happens in the blink of an eye. Ipso said, Peter, what could happen if ARCCA just straight up says they were hired by the FBI, or AJ says it? If a lawyer says he could be sanctioned, it could be major problems. It could potentially be a mistrial charge to the defendant. The defendant could potentially have to pay costs that the state had to waste trying this case, but it's not like a guilty verdict and she goes to jail. You would never want to do this if you're the lawyer, if you're ARCCA. You never want to do it. It's never worth the risk. It's not like you're going to go win the case. It's over.
So we're on 250 milliseconds. Does that sound right?
Sustained.
Let's move to the next slide, please. What are we looking at in this series of photographs?
So these are extracted frames from the high-speed video that we just saw on the previous slide, basically showing just at contact, just after contact, and then post-contact. So you can see the kinematics of the arm and how the arm is moving.
Okay. Let's move to the next slide, please. What is this photograph?
So Amanda said, after your pod with Better, I was worried the D is leaving too much on the table with ARCCA. They're going to drill reasonable doubt, not conspiracy. So from the jump, if you noticed, I don't think the defense should call all these witnesses. Some people disagree with me. Better disagrees with me. From the jump, I would have called Proctor. That's really the only thing I would have done different. Not Dever, call Proctor. Even if he called Dever, I would have called Proctor. That's it. I would not have expanded this too much. But, and I say this on the podcast with my dad, so I don't want to steal the thunder too much, but I'll reserve some so you guys can listen to the discussion more on there. Me and my dad were talking, and if this was our type of case, after listening to Dr. Russell and Dr. Wolf, and we know what Rentschler's going to say, that might be all we do as a defense, is just call those witnesses because they create what you need, simplify it to the jury, have the jury thinking about one thing. Don't have them thinking about how's long to die in the cold. Don't let them think about was he dragged or dropped. Like Russell, Wolf, Rentschler almost proves reasonable doubt to me. And I feel like that might be all we would have done. So even that as a strategy, I completely get it. From the outside, everybody wants to call everything. And sometimes, people get like, oh, it's so good. We've got to put every single good thing we have. But you got to make those tough decisions as a defense lawyer.
So this is photographs taken of the taillight after the 10-mile-an-hour test. I will note that there was a couple small fragments of the clear portion of the assembly, the outer lens that was missing from that turn signal area towards the left here. There's a couple fragments missing. And then there was some small fracturing here in that.
Emily, I appreciate this. And yeah, everybody was like, where's the recap last night? So the last couple I've just been doing it Saturday morning. It's been easy because every Friday night we've had a million things to do. So that's probably going to continue, although we might be done next week, maybe the next week. But yeah, I appreciate that. So doing this at 10 miles an hour was also incredibly important. I don't know if the defense knew, and it seems like they didn't know that the Commonwealth wasn't going to say it was 24 miles an hour. It seemed like they were going to say it was 24 miles an hour. But because they left that door open, doing this test at different speeds was incredibly effective because guess what? It wasn't 10 miles an hour. Doesn't seem like a possibility the taillight looks like it does if it hits an arm going 10 miles an hour.
In that area.
How would you describe the damage to the taillight at the 10-mile-an-hour test?
If I may go to the next slide, I think it might.
Sure.
So this was the totality of that damage at 10 miles per hour. So I would describe it as minimal and superficial.
Okay. Next slide, please. What is this?
So this is the photograph that I just shown you compared to that of the subject taillight so that you can have a side-by-side comparison of the test taillight compared to that of the subject.
Were you able to reach any opinions and conclusions about whether the damage to the subject taillight is consistent with striking an arm at 10 miles an hour?
It's inconsistent, in my opinion.
Next slide, please. This is still test A, is that correct?
Correct.
Were you able to reach any opinions or conclusions as to whether or not the damage to Mr. O'Keefe's clothing is consistent with being struck by the taillight at 10 miles per hour?
What I observed from the test is that there was no mechanism to create any of the holes that we observed on the subject sweatshirt.
Do you hold that opinion to a reasonable degree of scientific certainty?
Yes.
As well as the former opinion that you just gave us?
Yes.
Next slide, please.
So one negative, I want to point out a negative. That sweatshirt looks thicker than John O'Keefe's, but I don't think Brennan really brought it up. And they showed the tag like it's the same material. So, but if I'm just trying to look at this critically both ways, again, now we're talking about the holes in the sweatshirt or lack thereof. And that's incredibly important. And the fact that Jackson had the forethought to ask him about that in this set of testing and not just wait until later when they do it with the whole crash dummy is going to be epically important when you see the points that Hank Brennan decides to bring up on cross. I don't know if it was a bait and Brennan took the bait, but Jackson discussing it now, how when we just do tail light to arm with sweatshirt, no holes, guess what? That's not going to change. That's not going to change till we get to the crash dummy, and there's a reason for that. But incredibly important because this smashes what felt like a good point Brennan made on cross. I'm going to jump ahead a little bit. They talk about the money, which we've kind of talked about. $20K they paid ARCCA last trial, additional $50K. Obviously, comparing that to $400K looks a lot better for the defense. But the problem is that's not all ARCCA made. But that's all they can talk about because that's all the defense paid them. If they could talk about what the DOJ paid them, then that number would be a lot higher. But the judge is not allowing them to talk about that. So that actually cuts in favor of the defense, making it look like they spent a lot less money and they got a lot more testing. I mean, even just like, I think all of this test was done afterwards. So 50 grand for this test, to me, I mean, that sounds like a great deal from what I know. I paid some experts to do some testing, and compared to 400 grand, I don't pay that much. Right. So it's kind of interesting to see how the jury will look at that. What do you guys think about that? I saw somebody say, can you do a poll for guilty, not guilty? We'll do it at the end of the defense's case. We do it at the end of the Commonwealth's, end of the defense, and then the end of the case overall while the jury is deliberating. Is it possible the DOJ paid for some of these tests? 50K seems cheap for what they did in comparison to Aperture. I don't think the DOJ paid for any of this. I don't think so. When showing the speed of the car in reverse, wouldn't her car have hit Higgins' Jeep if it was parked right there? If it was parked there, sure. Might the defense call wing in rebuttal? Potentially. I also think there's a world in which they might call ARCCA. All right, I'm going to jump ahead a little bit to the next set of testing here. 17 miles an hour.
Reached a common velocity to the taillight.
Okay. Can we go ahead and go to the next slide, please?
By the way, one of the things I skip is like the G forces the arm has, where like it's transferred. So if the car is going 20 miles an hour, it hits the arm then starts going 20 miles an hour, which is important because how is the taillight going to explode if the arm's already moving 24 miles an hour out of the way? How does it have long enough to have that friction to make the scratches? To me, blows the Commonwealth's case apart, but I think Rentschler's going to talk more about that.
What do you note about this impact?
So now we're getting a busted taillight, which now if you're a guilty voter, you're with the Commonwealth, you're trying to see this best for the Commonwealth. See, at 17 miles an hour, an arm can bust a taillight. The outer layer of the taillight, right? You have to ignore the detail of the diffuser, number one. Number two, what happens to the arm is still an unanswered question because nobody on the Commonwealth side ever answered that question for us.
Impact.
So one of the things you'll see is kind of that dust cloud that you see. Again, that's all the particulates from the expanding foam that we use. So that's kind of what you see in the background there, kind of going over.
But Hank Brennan does a good job of zooming in on that and saying some of those are black pieces or red pieces or whatever, where it's not part of the foam. But I also kind of, if I'm Jackson, I'm like, couldn't you guys have used foam that doesn't explode and look like very small pieces of taillight? I think Brennan says, isn't that a microscopic piece of taillight? I want to be like, well, by definition, we wouldn't be able to see it if it was microscopic, right?
Kind of the arm and the taillight there.
Do you note more damage or less damage to the taillight at 17 miles an hour versus the 10 mile an hour test?
There's more damage, yes.
Let's go to the next slide, please. What are we looking at here?
So you're looking at a top-down view from the high-speed camera. You'll see the taillight enter from the left, impacting the arm at about 17 miles per hour.
Okay, go ahead and play it. Can you describe the decoupling that's shown here?
Absolutely. So as you can see where the two are basically married together, right? It's kind of actually coming back together now. So that bond that we had, right? This is the most effective way that we could mount it to the impactor. It just became detached due to the force of that impactor stopping at the end of the stroke.
Understood. Next slide, please. What are we looking at here?
So in this slide, you're looking at another high-speed video. This is just a side view. Again, you're going to see the taillight enter the frame from the left, impacting the arm at 17 miles per hour.
Is this in slow motion as well?
This is in slow motion, correct? Not real time.
Okay. What do you note in terms of the deflection on the arm?
The arm, as we saw in the previous one, is accelerated up, so it's moving out at roughly a common velocity with what the impact speed was.
And what did you note about the damage to the taillight?
It was more significant than the 10 mile an hour test, which again, there was very minimal damage to that, where several fragments of that red outer lens fractured as well as the clear lens.
Okay, next slide.
And he uses very good language, the red outer lens as well as the clear lens. Queen Bee, yeah, we talked about this. I would think if it was impossible, the defense would have brought that up. Alex, good luck to your son in his baseball tournament today. Hopefully the weather's beautiful in San Diego. Every time I've been there, it's been literally perfect.
And what is this depicting?
This is extracted frames from the previous video just showing right at contact, during contact, and post-contact.
Next slide, please. What is this a photograph of?
This photograph is depicting the damage to the taillight at the conclusion of the test, where, again, it's missing fragments of the outer red lens. I will note that the interior diffusers and plastic components are intact in this test.
When you say intact, what do you mean?
They are not damaged or broken.
At all?
Correct, at all.
Next slide, please. What is that a picture of?
Another photograph showing the taillight post-test. Again, no damage to the underlying diffusers in terms of being cracked, shattered, or broken.
And what did you note in terms of the damage to the outer acrylic, the red piece?
It broke into a few fragments, and I think on the next slide, I depict those in a photograph.
Let's take a look at that. What is that?
So this is a photograph depicting the collection of the fragments.
They went into detail about how different this was than what happened to Karen Reed's vehicle. That's why they proved it's possible, I agree, is a good point for the Commonwealth, but it falls woefully short when you look at the differences in what actually happened to the shattered taillight.
Fragments post-test. I will note there's one clear piece, one red piece, another clear piece, and there is one more red piece in this bag. So the outer lens broke into approximately 4 pieces in the 17-mile-per-hour test. And I'll point out one other thing just because you can see it in the photograph. This is that 3D printed bracket that we used to bolt it onto the linear impactor with the foam on the other side that mounted it to the taillight.
Thank you for that. Next slide, please. What is this a picture of, or pictures of?
This is a side-by-side comparison showing a depiction of the 17-mile-an-hour test impact to the test taillight, comparing it to that of the subject taillight.
Were you able to reach any conclusions or opinions as to whether or not the damage to the subject taillight on the right is consistent with striking an arm at 17 miles per hour?
It's inconsistent from a damage perspective.
What's the basis of that opinion?
The test that I just showed you all.
Was that testing that we've just talked about conducted in accordance with the scientific literature and generally accepted methodologies that you've earlier described?
Yes.
Is the damage to the right rear taillight consistent with striking John O'Keefe's arm at 17 miles per hour?
No.
Do you hold that opinion to a reasonable degree of scientific certainty?
Yes.
And I mean, listen, you can say busted taillight on both if you want, but I mean, just they couldn't look any more different. MAGA Barbie said, to me, it's silly to think ARCCA was effective for the Commonwealth when you think about how hard Hank tried to keep out that new testing. Yes, but the jury doesn't know that. And so the jury looking at it, if they're just looking for possibilities for the Commonwealth side, which would be legally wrong, it is checking those boxes that were not checked before. I had open-ended questions. Can you even shatter a taillight with an arm? Can you scratch an arm without breaking it? Can you do this damage at the same time where it shatters it and doesn't break the arm? But that first box, it is possible to bust this taillight open with an arm at the speed range that they say Karen Reed's car was going. But you'd have to ignore so many details. And that's the problem. Let me see if, all right, we're going to jump forward to the next set of tests here. All right, so this is now, we're going to go out. They have the Lexus. They're backing it up. I don't remember if they said how many feet this was, but they're backing the Lexus up. The Lexus right here, it's kind of like a white or cream color. They have a freezer out there. Have no fear because we got to keep that taillight at the right temperature.
You see the Lexus accelerate from left to right, impacting the hybrid suspended arm in the area where you can see the umbrella.
Can you use your spotlight and orient us? Where are the vehicles and the testing locations?
Yes. So the Lexus is starting here. You will see it accelerate in reverse with the hybrid arm suspended in this area here.
Okay. Is this a video or just a still shot?
This is a drone video.
Let's go ahead and play that. Dr. Wolf, is that in real time or slowed down, sped up?
This is in real time.
Okay. Next video, please. What is this?
This is a camera that was mounted on top of the forklift that was suspending the arm.
Is this a still shot or is it a video?
It's a video.
What is the orientation of that arm as it relates to the vehicle that we'll see?
So it will make contact with the taillight, although I will note in this test, ultimately the contact ended up being more of a clip or a side swipe in this test.
Go ahead.
That looks like a pretty violent hit, right? It looks like a pretty violent hit. And Brennan's going to be like, that's not the way an arm is set up, right? And he's right. And he's doing exactly what Dr. Welcher said. If you remember, Dr. Welcher's like, oh, if I did these testings, you guys would rip me a new one or cross me and, make me look horrible. And Brennan does exactly that on the things that are different. But that's not the point of the test. Every point of each test has specific points that it's proving. And by the way, All those where it was just the arm in the sweatshirt getting hit by the taillight, none of them had those puncture, holes, and scratches to the sweatshirt that we saw in John O'Keefe's shirt. None of them. And that's incredibly important when we're going to compare them when we do see holes here at some of these tests.
Did you see the impact area?
It's quick.
Right. What did you mean when you said more of a side swipe or a clip?
So I think the next couple of videos will help demonstrate that.
Let's move on to the next one. What are we looking at in this video? I'm sorry, in this photograph.
So this is going to be a high speed or a slow-mo video. You're going to see the Lexus come in from the right and then move across the screen to the left. And you'll see contact occur between the taillight and the arm.
Okay.
This is top-notch work. I will just tell you, top-notch work to give the jury the visual they deserve and they need in making a very important decision like this. And some guy, I agree with you. I agree with you. I was screaming that the entire first trial. Azam, can the Commonwealth call the defense witnesses? Yes, if they're on their witness list and if they're subpoenaed, yes, they can. Christopher Wells says, after reading comments on various streams of this trial, it's scary how many people believe that the defense needs to prove this or that instead of prosecution proving guilt. That combined with people being like, it's so obvious she's guilty. She drank. What else could have possibly hit him? Like questions like that. And it's like, oh, it's not the way the system's supposed to be set up. They've got to prove it. If they prove it, convict. If they prove it, convict, give the victims justice. I fight for victims to get justice every single day of my life. So I'm with you. But if they don't prove it, and if you have police work like this, it shouldn't end in a conviction.
Can you explain for the jurors using this video what you meant by more of a side swipe or a clip?
Right. So this is where the hand and the wrist are kind of in the area of the quarter panel taillight, and then a portion of the forearm in contact with, I'm sorry, what I previously said, the wrist and the hand in contact with the lift gate portion of the taillight. And then on the forearm is more in contact with the quarter panel taillight.
Okay. Can we move to the next slide? And what is this angle?
This is, yeah, same test, just a different angle with the high-speed cameras in slow motion.
And this is at 15 miles per hour, correct?
15 miles an hour, correct.
Can you explain for the jurors, given the fact that this is suspended, does that have any impact on the ultimate analysis or reconstruction, rather than being attached to an ATT?
Effectively, mass is mass. So whether we have an arm that is suspended or attached, again, it's the arm is on a joint, right? So the arm can accelerate freely of the rest of the body, right? So if anything, even if it is attached to the body, there may actually be some additional force associated with that, just because there could be more mass attached to it.
Understood. Okay, let's go ahead and play this video. Next slide, please.
And you can see that in this first one, a contact.
We're going to jump ahead now to the next test, which I think is 29 miles an hour.
Accelerating in reverse into the suspended hybrid arm over here at the location of the forklift.
Okay, if we can watch this video, please. Do your next slides show, there you go, the suspended arm. What are we looking at here?
So this is a video camera that was positioned on top of the forklift looking down at the arm. So you'll see the vehicle move from bottom to top as this video plays.
By the way, Dr. Wolf, what are the purple and white lines that we see have predominated? I'm sorry, I was talking about that.
Sorry.
That's okay. What are the purple?
And accelerating rearward into this.
Is this in real time?
This is in real time, yes.
What's the speed that the vehicle is entering the frame at?
29 miles per hour.
Thank you. What happened to the arm in terms of its suspension?
By the way, we are juiced up to like 1.3 times speed, so everything's going to look a little faster here and a little more violent. Because if you change the speed, everything changes, right? If you change the weight, everything changes.
Actually gets ripped off from the mounting location.
Is there a reason you believe physically that arm was ripped off from the suspension tethers?
Well, certainly there was enough force to break the tie lines to the forklift.
Was there a test value of those tie lines?
I think they were rated at 150 pounds.
What does that suggest in terms of the force that was exerted, just before we get to the other testing, the force that was exerted on the arms to tear off the tie lines?
Well, it indicates that the arm saw at least 150 pounds of force.
Okay. Next slide, please. What are we looking at in this video?
All right, now we're going to jump ahead to the crash test dummy, which is potentially the most important one. And this is the one where he's wearing the clothing, and we're going to see this again on Hank Brennan's cross.
So you're going to see the vehicle enter from the bottom going to the top of the screen.
By the way, when I'm watching some of these and I see how the hand is hit and how everything works, if he was holding that glass in his hand and he got hit at 24 miles an hour, wouldn't the glass be like 2 neighbors' houses down? Like, how would it end up right where he was? There's so many things I don't understand.
Next slide. What is this view?
It's just another perspective. This is a slow motion video where you'll see the Lexus in reverse. I think this one actually has kind of a long build up before it starts here. So this is a perspective from the high-speed camera. So
Before you play this, Dr. Wolf, I failed to ask this. It may be obvious. After each of the tests, C, D, E, F, were you replacing the taillight with new exemplar taillights that had been temperature accounted for?
yes, every time where
Again, it gives the jury a visual, like some people are saying, it gives the jury a visual of what could have actually happened that night. And that is that's a risky proposition for the defense. And Hank Brennan is going to use a lot of what did and did not happen in this collision in his cross-examination.
Next slide. In this configuration, was the ATD outfitted with the hoodie that you've earlier described?
yes,
At the time you outfitted the ATD with the hoodie in this configuration before this test E, did you confirm that the right sleeve, was damaged or undamaged?
after this test.
No, before.
Before it was undamaged before the test.
Okay. What are we looking at in this slide?
So this is still frames from the high speed. So starting out on the left here, just at contact. So the forearm making contact with the liftgate taillight, and then the upper part of the forearm and the elbow making contact, a direct hit into the quarter panel taillight. And the middle here is just after contact, and on the right is post contact.
Thank you.
So again, focusing on the clothes is important. MT, I agree with you. This case is very different. The defense has so much more to work with in this case than in your average criminal defense case, especially your average homicide case.
Next slide, please. What are we looking at in this video or in this picture?
So this is a overall photograph depicting the taillights subsequent to this test at 24 miles per hour. I will note that there's no damage to the liftgate taillight, and then there is damage to the quarter panel taillight.
Is there any damage to the internal diffusers on this taillight?
So if I go to the next photograph, if I may.
Please.
So you can see here, there is this kind of thicker, it's actually not a crack. So I'm looking at the clear diffuser here with the dots that you see. This line that you see, kind of opaque. I don't know if you've got a laser pointer.
Yes.
Line right here that's part of the assembly. So that's just a part of how the plastic is molded. There's a very small crack right here in the underlying diffuser.
Not shattered into a bunch of pieces. Again, these details are important. And if you're the lawyer, you're looking at the jury as you're asked these questions, making sure they're paying attention. If they're not, you talk about it some more. If they are, then you can move on.
But all of the remaining part of the diffuser in terms of this portion here and here are all intact, and same with this portion of it.
What about the chrome piece that's running between the diffusers?
I don't believe that was damaged during this test, no.
And what about the clear acrylic toward the top left of that taillight housing?
It was partially fractured, but not the entire outer portion of it.
Next slide, please. What is this depicting?
So this is a photograph depicting the quarter panel taillight subsequent to the 24-mile-an-hour impact test with the ATD arm compared to that of the subject taillight.
Based on this test, were you able to reach any opinions and conclusions as to whether the damage to the subject taillight is consistent with striking John O'Keefe's arm at 24 miles an hour?
Sustained in that form.
Were you able to reach any opinions or conclusions as to whether the damage to the subject tail light is consistent with striking an arm at 24 miles per hour?
Based upon the test results, it's inconsistent with striking an arm.
On what do you base that opinion?
I base it upon the test results that I've shown in terms of the video and the arm. We had data acquisition on the vehicle, monitoring the speeds of the vehicle. We accelerated that vehicle into the arm at 24 miles an hour to conduct a dynamic impact test to collect data certainly about the acceleration that the arm experienced, but then also make observations about the damage that we observed to the taillight.
Do you hold that opinion?
So I see a lot of people talking about like the distance to back up going that fast. I wish the defense would have really highlighted it if it was good for them, right? And that's usually what I rely on. I try not to. Jurors do all the time. So I'm glad you guys are doing this. Jurors fill gaps all the time. Sometimes it's good, sometimes it's bad for your side, right? But I'm glad you guys are doing this because I usually don't. If it's important, the defense needs to make sure I'm focused on it. And this was another good point. Nicole said the jury still doesn't know about her connecting to the Wi-Fi. They need to bring that in also. They do know. Garino testified about that ages ago, but it hasn't been highlighted. And I would have highlighted it with basically every witness that talked about that timeline. But I agree with you, and Nicole's making a point that maybe it hasn't been highlighted enough. It definitely has come out. It is in evidence, and the defense is allowed to argue it.
In that we just discussed to a reasonable degree of scientific certainty.
Yes.
And were your tests?
So we're gonna jump ahead to the last test and his overall opinions.
Okay.
So this is him getting hit and his body projecting forward, which again, as a visual, if I'm the Commonwealth, I would like this. This is what it looks like. This is what it looks like. Look, gets hit, flies forward, breaks the glass, hurts his arm, right? Like if you want to simplify it, you want to remove a lot of the details, this is what you'd want.
Can you play that one more time, please? Next slide, please. What are we looking at in this series of photographs?
So this is a extract from our VBox software and data acquisition system. So on the top, you'll see the video. On the bottom is the data. So this is another feed that we had, a video. This was triggered. So we do have data from this perspective. So what you'll see is my colleague will move away from the assembly with the dry ice, and then the vehicle will accelerate in reverse.
That was my question. The blue, that's dry ice gloves?
You don't want to touch dry ice with your bare hands. So it's, he's wearing gloves. He's capturing the thermal images now.
Next slide, please. And what are we looking at in this?
So these are extracted frames from that video you just saw from the data acquisition system. So on the left here is just before contact between the test dummy and the Lexus. On the right is just at contact.
Next slide, please. And what are we seeing in these series of photos?
So this is obviously during the collision sequence. The body now has loaded into the lift gate and the back window. What you're seeing here is the back window shattering. And this is just a few split second later in time where, again, the body is continuing to move with the vehicle as it's contacted.
Next slide. And what is this?
This depicts the post-impact damage to the rear of the Lexus. As I noted, the rear window is completely shattered. There's deformation and crush to the liftgate section of the vehicle. The bumper step was popped out, and then there was some minor fracturing in the bumper cover at the lower level.
Did you note anything regarding the internal components of the exemplar taillight, even at this direct impact?
So the taillight, as you can see,
I mean, look at how smashed up that Lexus is. I mean, that thing looks like it's been in an accident, right?
it blew out the outer lens cover. I believe the part of the clear diffusers were actually still in place. I think the lower one might have been fractured here, but I think the upper one was still in place.
At 29 miles an hour with a direct impact, did the exemplar taillight exhibit the same type of damage to the diffuser as the subject taillight?
I'm not sure I understand your question.
More or less damage in this photo to the diffuser specifically than in the subject taillight?
Well, I think there was more in the subject taillight. As I mentioned, I believe the top diffuser
More
on this
damage?
Correct.
Okay, that was my question. And is there another slide at the on the back end of this one?
That's it.
Okay, we can have the lights. Dr. Wolf, you conducted tests at what miles per hour? Tell me the sequence.
It would be 10 miles per hour, 17 miles per hour, 15 miles per hour, 29 miles per hour, 24 miles per hour, and then a full-on hit at 29 miles per hour.
Regarding all of the tests you conducted, what did you observe with regard to the damage, if any, to the internal components of the quarter panel taillight? And I'm talking about the chrome pieces and the diffusers.
It was less in all of the tested taillights than that of the subject taillight.
Did you reach any opinions or conclusions as to whether the damage to the right rear taillight of the subject 2021 Lexus is consistent with an impact to John O'Keefe's right arm during a high-speed reversing maneuver?
Sustained in that form, Mr. Jackson.
Did you reach any opinions or conclusions as to whether the damage to the right rear taillight of the subject vehicle is consistent or inconsistent with an impact to a right arm during a high-speed reversing maneuver?
It was inconsistent.
What's the basis for that opinion?
These are his overall opinions now. This is kind of the end, the crescendo of the direct examination. I thought this was Alan Jackson's best direct of the entire, both trials combined, maybe. People were saying Alessi should have done it, whatever. I think Jackson had experience with these people. I think Alessi could have done a great job as well. That's, I think, the point about this team is they made separations. Certain lawyers handled certain things, but overall, they all did such a good job with the parts they had that I think if they would have been able to dig in, this was their portion of the case. This was going to be their job. I think they were going to do a good job with it. And I think this kind of proved that because I thought this was an amazing direct.
Opinion.
All of the test data that we did from the laboratory testing, moving up to full-scale vehicle testing, all of the collected data in terms of the photographs, the observations, all the acceleration data collected. So all of the testing that we've walked through in this PowerPoint, along with certainly that was based upon all generally accepted and peer-reviewed methodologies in the accident reconstruction community.
Do you hold that opinion to a reasonable degree of scientific certainty based on your experience, training, and education?
Yes.
Did you reach any opinions or conclusions as to relating to the punctures, holes in the hoodie that you saw that was related to John O'Keefe?
Yes.
Do you have an opinion or conclusion as to whether or not the damage that you saw to the hoodie related to John O'Keefe is consistent or inconsistent with a impact from a right rear taillight of the subject SUV?
It was inconsistent.
And what do you base that opinion on?
Based upon all of the impact testing that we did with the closed ATD arm in the laboratory as well as the field.
In any of the testing that you did you ever see taillight pieces cut, puncture, or fray the sleeve of that hoodie?
No.
The exemplar hoodie, I should say.
Correct.
Did you reach any opinions or conclusions as to whether the rear taillight of the subject SUV was involved in a center of mass strike of a pedestrian at a high-speed rearward maneuver?
Yes.
What is your opinion?
That the damage to the subject Lexus is inconsistent with a center of mass hit.
What do you base that opinion on?
The testing that we conducted in that last test that you just saw.
Do you hold that opinion to a reasonable degree of scientific certainty, Dr. Wolf?
Yes.
Thank you. That's all I have.
All right. Here's a good place.
So that's it. That is the end of Dr. Wolf's direct. And now we'll get to his cross. I'm going to answer some questions here before we do. Kathy, it's frustrating they're not calling Proctor. Jackson mentioned him in opening, so could not calling him really hurt the defense? I really don't think it's going to hurt the defense. I think it's so much worse for the Commonwealth that they're not calling their lead investigator than it is for any negativity they're going to have for the defense. And the defense is going to argue about him plenty. Do you think, and I don't think Brennan's going to be like, well, they could have called him and they didn't. Do you think ARCCA disproved Karen Reed's own theory of one Meadows reverse out of the driveway, hit JOK's car, broke the taillight, having coffee right now in a new lawyer you know mug? That's awesome. They didn't really get into it, and Brennan didn't really get into it on cross either, so I'm not sure what the jury's going to take from that. I hope they bring up how the diffuser on Karen Reed's car was broke and wasn't in the tests. Much direct force needed, maybe in rebuttal. They did bring that up. I thought that was a main thing I got because I didn't fully understand that until they really broke it down here and dumbed it down to my level. Therapist, might have been confused, but has Hank been getting the last rebut on defense witnesses? Sometimes, yes, but she let Jackson do that as well. And Alessi. She's let too many redirects and recrosses, in my opinion. NYC. Why would the Commonwealth have done the paint demo in a short sleeve shirt? Leaves out the sweatshirt punctures entirely. Aperture looks like a high school forensics team. The only thing I can think of is the results were not going to be good for them. I feel like the debate has switched from, is the Commonwealth proving their case beyond a reasonable doubt, to whose version of the events is more likely. That's very dangerous, and you have to be careful about that for the defense. Is that the defense is failing? No. How would you handle that issue? Focus on reasonable doubt and the fact that what they're proving is not exactly what happened, just that the Commonwealth has not proved what happened. Do you think the defense should call Wing? Maybe he did a test with an exemplar hoodie, having a German Shepherd bite them on the arm. This could show puncture holes in the sleeve. I don't think they're going to. I don't know what he was going to say, so it's hard for me to say whether or not they should call him. It's different than Proctor, where I know some of what Proctor's going to say. We'll see if they call him in their rebuttal if they get there. For me, lack of testing for the Commonwealth shows laziness. With all that money they were paid, that's why they chose to do. Yeah, not great. Randy Defense Fund, hashtag justice for Randy. Did anyone prove what kind of forces it would take for John O'Keefe to shatter the light, be found near the flagpole, and no bones broken in his elbow and neck? I think that Rentschler's going to handle that last part of what force would have broken bones. How can Welcher be allowed back to do rebuttal when they were only doing tests to rebut his testimony because the judge is going to allow it? I've told my husband over and over, first, show me a simulated arm could similarly smash the taillight. Second, that the taillight could cause those injuries. If you can't show me either, then it's a not guilty. Or the arm breaks the taillight but doesn't shatter the arm in that combination. I'm saying intoxicated people are loose when they get hit or go through a car accident. Things may not get broken, i.e. like John's arm. So Rebecca, I would expect, and I know you're the ER person here, and I know you posted that other comment about, they cannot break bones, but I would expect bruising. I also don't understand the scratches. Explain to me how the scratches got there if the taillight exploded at the same time it was hitting his arm, based on how Dr. Wolf explained it. That doesn't make sense to me. What do you think of Brennan poking holes in the Commonwealth's theory of holes in the shirt? Does he forget what side he's on? It does feel a little bit like he's poking holes, which isn't great when you're trying to prove a case beyond a reasonable doubt. Peter, while AJ asks great questions, I feel like sometimes he doesn't bring it all together and make clear what the jury should take from it. I feel like I get it. Maybe some jurors do, maybe some don't. Maybe you like, how Alessi says, here's what I'm going to do. He does it. Then he says, here's what I just did. Everybody's got a little bit of a different feeling on it. Thoughts on the best point Wolf made to disprove the Commonwealth theory? In my opinion, it was lack of internal taillight damage during testing and how much force is needed. I would agree. Lack of the internal damage and lack of the damage to the sweatshirt the way that it happened in this case, if the accident happened this way. Those are probably his two best points. Peter, is there a reason why the defense doesn't seem to object very often? Object when you need to. You don't just need to object just to object. And I think they trust their witnesses, and they think their witnesses are going to do a good job. And they could have objected a couple times during Dr. Russell, and maybe they would have missed out on some great answers that she gave. Do you think John O'Keefe will ever have justice? I think that depends on who you ask. I hope he does, but we'll see how it ends, and then what his family thinks. And there's just a lot still going on. Okay, let's get into cross. We talked about kind of the experience stuff that he hit on. Oh man, the test that Dr. Wolf took, that Hank Brennan was like, well, you had to take one of those tests, one of the parts of those tests twice, didn't you? Because you messed something up. Now, I thought it was good foundation for something Brennan asked later, which he didn't connect, which I thought he would. But to act like, so you had to take the second part of a test twice makes you stupid or not able to be an expert or not supposed to be here. That's a judge question, number one. But he tried to hit his credibility with that. And I can understand that in certain cases. And if you have an A+ expert, and if he thinks Dr. Welcher's an A+ expert, fine. But with the educational issues of Hank Brennan's questions, I probably would have not gone that route with talking about how you did pass the test. You are certified, but you had to take it twice. It's like 17 years of college. Like, to me, that was a swing and a miss by Brennan, but he had to go for what he had. Then we get into, and I know Betterow and I, when we talked about this, he said, oh no, I don't think Hank Brennan's going to go after these texts. And then later when I talked to him, he said, yeah, he probably is, once we've seen how Hank Brennan's crossing every witness this way. And oh, he absolutely went after you tried to act like you were independent and you weren't. You're trying to help the defense. Let's talk about your texts and let's hear how this came out. And you tell me, was this effective getting in front of the jury?
Substance when you text somebody, isn't there?
Correct.
And when you texted, how many texts do you think we had with the defense?
From what I recall, I think it was around 50 texts that I sent.
It wasn't 100, I think it was 50.
Well, I think it was around 100 total in terms of back and forth, but it was, I think, 50 that I sent.
And during those texts, there's communications, conversations, correct?
About logistics, yes.
Did you provide the content of those text messages when you were ordered to by the court?
Well, those text messages spanned from, I guess it would have been April or so of 2024 through May to June of 2024. Ultimately, I think I received the court's order in May of this year, April of this year. So it was a year after the fact, and I had already deleted the text at that point.
How many of those text messages did you delete?
I just swiped the conversation, so it would have been the whole conversation.
Not how you did it. How many of those hundreds or so text messages did you delete, sir?
It would have been the whole text chain. I didn't individually delete them. It just, when you swipe, it just deletes the text chain.
After you deleted them, did you go into the recently deleted and then delete them so they were unavailable?
I don't recall doing that.
Well, you were asked to search your records of the text messages. Did you do a thorough search to see if you still had them or whether you had destroyed them all?
I checked my phone, and I also checked with my phone carrier.
So do you know if they were still under the recently deleted part of your phone, or did you go and take that extra step and totally destroy them?
From what I recall, I did not find any of the text messages, no.
Is there any reason why you deleted all of your text communications with the defense?
Well, it's something that I routinely do. I work with attorneys and clients all the time, whether it's appearing for trial or inspections, and I don't have a habit of keeping a text chain that talks about logistics and things. It's just I routinely delete them after that communication was over with, and certainly after the prior proceeding, once it had concluded, there was no reason for me to preserve those.
And so at some point, you switched from text messages to another form of communication, didn't you?
Yes, earlier this year.
Tell us a little bit about this new form of communication, not text messages.
So Mr. Jackson had indicated that he and his defense team utilized an application known as Signal for their communications amongst their defense team. Ultimately asked if I would also use that application to communicate, which I agreed to.
Is Signal an encrypted app?
It's a secure encrypted app, yes.
It doesn't leave any records, right?
I don't believe so, no.
Well, you're using it. Do you have any records from your Signal use?
I'm going to allow that.
Do you have any records from your Signal use?
I do not, no.
So you know full well that Signal is an encrypted
By the way, I missed the hour mark to tell everybody to hit the like button. So hopefully you guys have hit the like button. If you haven't, hit it now. We're going to go through this entire cross. We're going to go through redirect. Then we'll be done here in short order. But make sure you guys hit the like button if you have not already.
that leaves no record.
There may be a setting that you can change. I just know that the way that it was set up, there was no record.
Well, who set yours up to have no record?
I don't know. I think it was default.
Have you ever checked your Signal app to see if you have any record of your communications pursuant to that court order?
Well, I don't have the application anymore, but at the time I did check the application.
Out of all these clients that you've had, how many times or how many clients would you use Signal with?
This was the first time.
Have you used it since with other clients?
Not yet, no.
So again, that could be effective if you don't trust him and you think he's slimy and you think he's shady and you think the fact that, he didn't tell you he worked for insurance companies and that he had to take his test twice. So it really depends on what the jury thinks about Dr. Wolf before they hear those. If they didn't like him, that's probably going to make them like him even less. I feel like he came off pretty likable during direct. So they're probably going to be like, what's the big deal? And then how many of the jurors have used Signal? That's a big question. We just don't know the answer to. If the diffusers are broken, does that not jack up the Commonwealth's theory showing the lights were working on the towing and 5:07 a.m. video over taillight? I honestly have no idea. He didn't explain to me that. Maybe he did and I missed it. Did he say if the diffusers are all busted up, the light wouldn't turn on? I don't know the answer. It seems like Bev is being overly protective of the Commonwealth with the sustained objections and not letting certain evidence in like you would for a defendant to protect their rights. It's so maddening. Those numbers are pretty wild. Emma, hi, Peter, 40 plus pieces of taillight supposedly causing all that damage to his arm, yet not one piece gets stuck in his arm or hoodie. Also, wouldn't some of those pieces have blood and DNA on them? You would think yes to all of those. But is the debris that they found in the sleeve going to be enough? Because some of the jurors in the last trial felt like it was. Joe, the Commonwealth hasn't explained how an impact to the arm caused a skull fracture, the actual cause of death. Trooper Paul at least said he was projected. Welcher didn't. If she struck his arm, but he fell on his own after, is it her fault? Yes. If her striking him, pirouetting like Paul said and falling, or hitting his arm, causing him to fall, hitting his arm, causing him to slip, lose his balance like the other Dr. Wolf said potentially, then yes, it would still be her fault. But I get what you're saying. They haven't exactly said that. But that is a reasonable inference a jury can make from the evidence. So that's how it works is even if you don't prove every single link in a chain, as long as you prove everything that, okay, she hits him in the arm, he does some kind of movement, falls backward on his head, and the injury to his head is consistent with hitting frozen ground, then they can make that reasonable leap. Now, the problem is all the reasonable doubt mixed in with, did she actually hit him because of what the taillight did, what his sweater did, what his arm did, and how all of those don't necessarily match up with the science. But if they got to that point where they said, we think she did hit him, the taillight was damaged by his arm was damaged by the taillight, then it would be a reasonable inference that he ends up on the ground because of that, hitting the back of his head. I think that was your question. Hey, Peter, you played golf yesterday. Did you record anything with your new phone holder? No, I haven't had time to even set it up yet, but thank you so much, Gene, if you're the one that sent that to me. I appreciate it. Why didn't ARCCA test Karen Reed's car, bumping into John O'Keefe's car, and the potential damage? My guess is the defense didn't ask them to. Queen B, please tell us why they can't say FBI, because the judges found that it would be prejudicial to the Commonwealth and confuse the jury because they'd have to get into everything the FBI has done in this case. Do you think Karen Reed intentionally misleads the press on when the defense will rest to throw Hank and the Commonwealth off? I do not. From a strategic perspective, how much benefit do you think the defense gets from this testimony and starting redirect prior to the weekend versus ending with Brennan doing cross? I feel like ending with this info is very powerful. That's a great question. Something I didn't really think about. Very, very important because Jackson did a really good job ending redirect right before we went into the weekend. Okay, let's jump to the next section here. Talking more about, well, you wanted to say, or you told the defense, I won't say this if you don't want me to, pedestrian accident, even though you did say it, but you're definitely trying to mislead this jury. Brennan's trying to get it to seem like Wolf is trying to mislead the jury.
Don't want me to say this, that's fine. Why did you include a note to the defense that if they didn't want you to say something that you thought was important, you would leave it out?
Well, I think because I didn't want to confuse the jury about a statistic that just because we have inclement weather and dark lighting conditions, it doesn't automatically equal a pedestrian impact, right? We have to look at the evidence and the damage to the vehicle and the injuries to determine whether or not a collision occurred, not the visibility.
So you weren't trying to mislead the jury, you were trying to help them because they wouldn't understand something that you were trying to explain? Is that the way you're phrasing this?
I think at the end of the day, it was to help them understand my background, how it relates to seeing a lot of pedestrian impacts.
Something was important. It helps the jury get to the truth. Why would you offer to leave it out?
Well, I didn't leave it out.
No, you offered to. You would have to request it. Why did you invite, why did you invite somebody else to interview?
So you see how he interrupted him? He said, excuse me, cutting him off. Again, just rude. Like if I'm sitting there, I'm like, ooh, I'm cringing a little bit. And that wasn't the last time this happened during cross.
You would have to request it. Why did you invite, why did you invite somebody else to interject in your...
And his demeanor, like most of the defense witnesses, really good even with that point. Didn't try to buck up. He's giving grace, right? Do it as a witness too. It helps, makes you look better.
Independence and guide you to leave something out. Why would you even provide that invitation to them?
Again, it's because I didn't want them to get hung up on a statistic that just because we have more pedestrian impacts at night and in bad weather, that this alleged incident happened at night under bad weather, to give it more weight, to weight the evidence more because of that statistic. You done? Yes.
If you
Again, it's like, bro, that is not it. That is not it.
make a mistake in court under oath, would you take the affirmative step on your own and correct that mistake?
I'll allow it.
I would do my best to do that, yes.
Well, when you say do your best, would you do that if you became aware of it?
I'll allow it.
Yes.
This is also like, how do you do this? Right? How do you do this?
Before you testified in a proceeding last year, there was a hearing that you testified in front of Her Honor and other people that were here, correct?
Correct.
I wasn't here.
No.
You were.
Yes.
And you testified about your experience, didn't you?
Correct.
When you were
Yes.
sharing your experience with the court, it was important for the court to have an accurate understanding of what your experience was because it was being evaluated in that hearing, wasn't it?
Correct.
When you testified to the court, you testified that you had been qualified as an expert to testify over 20 times, didn't you?
I don't have the transcript. I believe I said approximately 20 times.
And it turns out that it was only 11 times at trial and 7 depositions, which is 18 times, not 20 times. It's like, Brennan, what are you doing, man? That's just, that to me, a lot of people said, oh, Brennan feels desperate with this question or desperate or grasping his straws. I haven't felt that much as often as you or the chat or the public has felt. This, with this witness taking the test twice and 18 versus 20, that was just a miss to me. That was, I don't know what the jury thinks, right? I'm not sitting there with the jury, but to me, I would be like, yeah, that does not seem like it's as impactful as you think it is. And I agree with this strains. This is where it started to really start to feel like that's not great. That's not great. Then we get into, the wife stuff, right? So he follows this up with, does your wife favor one side or the other? He's like, not to my knowledge. And he shows him something. I don't know if it's a Facebook group or a post or something his wife said. He's like, I've never seen that. And because he's never seen it and didn't have knowledge of it, Judge Cannoni did not let Hank Brennan to go any further because there's no foundation for the knowledge of this witness to testify about this subject of which side or the other his wife favors. Now, I thought it might open the door to some of the people coming at him, but I think it looks better and more professional to just keep all that outside noise out. And that's what they were able to do because this guy is a professional witness with great demeanor, answering honestly, and trying to focus on what he's there to do. I don't want to get in the sideshow circus, okay? I want to focus about the testing that I did and my expertise, and that's exactly what he did do. Then he starts asking footnotes of Dr. Welcher's report. Did you read Dr. Welcher's report? Trying to ask him about Dr. Welcher's report, which is not what he's testifying to, and the Commonwealth has objected to that in other situations, yet they wanted to bring it up here. He wanted to impeach, Brennan wanted to impeach Wolf with Welcher's report. I keep saying Welcher. Rentschler's report, he's like, I read it, but Rentschler's the one that's going to testify to that stuff. All right, let's listen to the next section here.
Were inconsistent with causing any type of holes in clothing similar to Mr. O'Keefe's. Or
here we go. This was a big part.
On his arm. You knew that was going to be part of your opinion today. Yes.
Yes.
As part of forming a valid opinion that people can rely upon, wouldn't you want to do as much study as possible on the background for that opinion before you give it to a jury?
I suppose, yes.
Well, you suppose. Don't you think if you come in here as an expert, the jury is relying on your background and education?
What? When you come in here as an expert, the jury is relying on your background and education? What does that make you think of? What's the first thing you think of when Hank Brennan says the jury is relying on your background and education? I mean, I feel bad for Burgess at this point, but he just keeps popping in my head.
Yes.
And they're relying on the fact that you're representing something definitively or with an opinion to a reasonable degree of certainty. You understand that, right?
Yes.
And don't you think when you do that, that it's important that you have proper study and foundation before you just come into court and give an opinion?
Well, I will note that the ATD crash dummy is a generally accepted test device to use for not only assessing occupant forces in motor vehicle crashes, but also to assess impact forces. So that the use of that device is certainly generally accepted.
When you get uncomfortable with my question, you generally tend to answer a different question.
Sustain, Mr. Brennan, next question.
When you get uncomfortable with my question, do you generally start to answer a different question? I mean, that's just, it's like, oh, it's like why people hate lawyers, right? Why people hate, I get it, right? I always say that. I get why people hate lawyers. This feels like that reason. Why are you acting like this, dude? And it's not over.
Strike that, jury.
Let me ask you again. Don't you think, as an expert, it's important when you come in, you're going to present an opinion based on science or engineering or whatever you want to do, that you study the basis for that opinion before you give it?
Yes.
When you saw in Dr. Rentschler's report references to this very issue about what should be used when you're doing demonstration or study of what can cause tears to clothing, weren't you interested in the basis of those opinions?
Well, again, it was something where Dr. Rentschler and I worked together, and we were in agreement that we could utilize the ATD arm clothed.
When you decided to have an agreement that you could use that arm, did you read the book that he cites as support, Forensic Pathology, 2nd edition, Vincent J. DeMaio? Did you read it?
No, I did not.
Did you brief it?
No.
Did you peruse through it at all?
No.
When you decided to come to this agreement that's going to have a foundation for your opinions, did you look at footnote 26, understanding the acute skin injury mechanism caused by player surface contact during soccer, a survey and systematic review? Did you do that?
No, sir.
Have you seen any articles that support the proposition that a hybrid 3 arm of a crash test dummy is appropriate to use when you're trying to provide a foundation for an opinion about whether or not tears can happen to clothing or abrasions to skin? Do you have any support for that in your report?
Well, again, Dr. Rentschler is going to be addressing the... You're shaking your head.
So I'm going to let him answer.
You're shaking your head. Like, it's so obvious, I think, to the people in the courtroom that this is just not how you want to act professionally. Somebody said, Peter, can a witness call out a lawyer? Yeah, sure, but it won't look good. It will not look good if that's exactly what happened. Will Welcher keep the sequestration order for rebuttal? I think so. I didn't hear if the judge actually instructed him on that, but I would think the answer to that would be yes. Peter, I sat on a jury in New Hampshire last month and was stunned. Some of the jurors were hung up on the fact that the defense lawyer was a bully. This is not as uncommon as you might think. Okay, so now let's get to a couple good points Hank Brennan made. There is a crash test dummy arm that is 11.8 pounds. Sorry, that is 12 pounds. John O'Keefe's arm, according to the statistics, was close to 11.8 pounds. They chose to use one at 9.4 pounds. The crash dummy they picked was 5'9", 170 pounds. There's one closer to John O'Keefe, 6'1", 200 pounds. So I'm like, why? If I'm Jackson, I'm thinking, why did you do that? Is it the biggest deal in the world? No, but why give them any fodder? That was a little frustrating. I'm like, I wish you guys just would have picked the one. Now, great point in Jackson to bring up on redirect. Did anybody weigh John O'Keefe's arm? Do we know exactly what John O'Keefe's arm weighed? No. So that definitely minimizes the effect, but I still think it was a good point to bring out by Brennan on cross to show the inconsistencies and how things may change. But then Brennan tried to take that percentage and apply it to everything. Like the percentage the arm was short in weight, which may not have even been the right percentage, and then apply it to every single number, which is just not how these equations work. But this is Brennan trying to twist things to make it work from his perspective. I thought this is what he was going to connect that back to the test because Dr. Wolf said he missed something on the test because if you put one data point in wrong and you do all the equations, even if you do all the math right, it's going to come out wrong at the end. I would have brought that back up and been like, Brennan, if I was Brennan, I would have been like, this is kind of like what you did on that test that you failed where you picked the wrong data point and all of your information is going to be wrong, even if you did the math right. He didn't do that. He didn't necessarily connect them together. I thought it was a good point by Brennan, but not overly convincing, especially what Jackson did to it on redirect. And then, of course, he talked about body position changes, everything changes. Obviously, yes, but we're still proving individual points. What does it take to shatter the outside of the taillight? What does it take to shatter the diffuser? What does it take to make the holes in the sweatshirt? What does it take to break an arm, right? Those are the questions we're answering that Welcher just completely avoided. So let's listen to the discussion about holes in the clothes, which I thought was a pretty good point for about 5 minutes until Jackson got up on redirect.
Demonstration where you didn't turn on the videotape, so we don't have a videotape.
Correct. We had the false start. Yep.
What's that?
We had the false start.
False start. Is there another picture after this? Those clothes. Are there holes or tears in the clothes?
Yes, there's damage that's consistent with road rash when clothing or a body makes contact with the pavement and is grinding into the pavement.
Pavement's hard. Right?
Yes.
How about frozen ground, frozen dirt?
So he does a good job explaining road rash, but it's a pretty good visual for the jury if I'm Brennan. Like, hey, look at these holes. Not exactly the same every time, but look at these holes. They look a lot like the holes in John O'Keefe's shirt.
Is that hard?
Yeah.
I suppose it can be.
Well, do you have any doubt whether frozen ground in the Northeast in the winter is hard as a rock?
I haven't done any analysis to assess that.
And so seeing holes in those clothes is what you would expect after Randy hits that hard ground, right?
Are you talking about frozen grass or pavement?
I'm talking about Randy right now. These holes in the clothes are what you would expect after Randy hits the hard ground, correct?
I'm going to allow that. Is that what you'd expect? All right, jurors, feel free to stand up and stretch.
So again, I thought that was a good point for Brennan until Jackson gets back up. If you add weight and speed, the damage will go up. Yes. Then he tries to get him to say there were no lower body injuries. I thought Brennan made an okay point there too. Like he got hit, it didn't hit him in the leg, et cetera, et cetera. Well, Rentschler's going to talk more about that, but again, good question to ask. Shoes could fly off, hat would fly off, et cetera. And again, I think all of those decent points by Brennan at the end. I would have shortened this cross even a little bit more, but some of his most important and biggest points, we're going to listen to Jackson crush them on redirect here. Let me answer a couple questions. Derek, Peter, it was real. She did say yes. Thank you for the help on it. She came over for dinner and I had already seen it live. So we put your show on and I just let it play out. She was shocked and happy. I want to believe this is true, Derek. Love is in the air. I think the chances are Karen Reed spun in the snow when driving away from Fairview. I don't see how else she would have gotten to that speed. Can the jury find Karen Reed factually innocent No, that's not one of the options. It's guilty or not guilty. On rebuttal, could Alan Jackson ask Welcher why they didn't do similar testing ARCCA had done, especially if they had the budget of $380,000? He did that was kind of part of the cross already with Welcher. Why didn't you do this, that, and the other? I'm guessing it's just by experience, but how do you push down that fear of, did you answer all the jurors' questions with the witnesses you chose? I was surprised what questions just weren't answered for jurors in trial one. So here's what I'll say about this, Jojo. Lawyers deal with this every single trial. You control what you can control. Don't beat yourself up about it. It's just like you give an opening statement or a closing argument, or you do a video on YouTube. It's never going to be perfect. You're never going to give every answer the way you want to. You say a lot of words. It's never going to come out perfectly, but you have to be resigned to prepare, do your best, and what's going to happen was going to happen, and you hope that right comes out ahead of wrong more times than not. And Sanford. Also, looking at both sides' presentation, AJ committed in opening statements he would prove J.O. was hurt inside the home. Defense has abandoned that statement. Will jury hold that against them? I don't necessarily know that he said it quite that outright. I don't think they've abandoned it. Like, even when you think about Ian Whiffen, they're like, so John O'Keefe could have been inside the house. So they've done a little bit of it. I don't think enough to where it's going to be held against them. Can Brennan still get into Wolf's wife comments and participation in FKR FB group support on recross, or no, because he denied, aka lied, knowing meaning foundation? Unless he found something over the weekend that proves Wolf does know about that and has seen it, I don't see how he gets into it. In your experience with jury deliberations, what can you say about the time it takes for them to come back with a verdict? On something like this, I do think it's going to take longer than you'd think. It's not going to be one day. I think it's going to probably be multiple days if there are holdouts. Wouldn't the glass tear up his hand? You would think. Peter, do you realize this is the only channel left that AFKR feel they can mouth off on? Your platform is all they have. Care to address Forrest Dump? Let me just tell you, I don't care. I don't care. People are not going to force me to be one side or the other, okay? And people's definitions of mouth off, right? I want to hear people's opinions. I'm not going to read somebody being a jerk. If you go look at my Twitter, people are a jerk to me all the time on Twitter. I ignore them. I would advise people to ignore jerks. But just because somebody thinks that Karen Reed is guilty doesn't mean you should dismiss everything they have to say. I think talking about it, I think we found out on the last jury, 8 people were willing to vote guilty. So people cannot pretend like there's not a way to see this case and see that she is guilty. I think there's a lot of people that think she's factually innocent that are starting to understand there are ways that you could see how somebody gets guilty. We can disagree with it. I disagree with it. I think this is as not guilty as you can get at this point in the trial. I really do. I think there's so much reasonable doubt here. But I think to say like I need to kick everybody off that thinks that she might be guilty, that's just not how it's ever going to be here. So I don't want to, sound insensitive to people that may disagree or feel like somebody's being a jerk, but I like to hear differing opinions. I like to have diversity of thought. I like to myself try to see things from both sides. And I know people hate that and people get really frustrated by that. No, he's a fence sitter and blah, blah, blah. And it's like, I don't think you understand what I'm trying to do here, because I'm not trying to convince people or force people to see it one way or the other. And I'm not meaning you, but I mean like some people on Twitter and whatever that really want to come at me for that. That's just not how it's going to be here. And I'm going to try to give everybody grace as much as I can. They may say a nasty comment to me, then be like, hey, my bad, that was too far. And that's fine. I'm still going to have open discussion with them. Peter, besides the results, do you think the jury weighs favorably that they only got to see it through, thanks to Karen Reed? In my opinion, the mere fact that she wasn't afraid, or less than the Commonwealth at least, just speaks volumes. I agree. And I would from my perspective. That would make a big, big difference and be a big deal to me that the Commonwealth didn't bring up this stuff. Karen Reed did. All right, let's get to some of the cross here. Or sorry, some of the redirect.
Any of those in the PowerPoint.
Okay. The photo that you showed, if I could ask Ms. Gilman to show the same photograph that she showed earlier of the subsequent to test F as in Foxtrot with the holes in the sleeve.
If she can.
If she can.
Can you do that, Ms. Gilman?
Very kind.
Thank you.
Dr. Wolf, you're showing just the left arm underneath the, whatever you call the dummy, Randy, right?
Yes.
Did Mr. Brennan show you the rest of the sweatshirt?
No.
What did the rest of the sweatshirt look like after this full-on impact when he was launched on the asphalt?
Mangled. So there was not only significant road rash to the clothing all over the torso section, the left arm, the right arm. There was holes in many different locations of various sizes. There was also just on the skin of the dummy, there was road rash on the face had been scraped. The torso had been scraped. So there was significant body damage to the torso as well.
Taking just the sweatshirt, separating that out. What about the bodice of the sweatshirt, the front of the sweatshirt? Were there holes and frays and damage to the front?
It was covered in all of those, yes.
What about the back of the sweatshirt? Did that also have damage?
I don't believe the back, because I think he fell onto his stomach.
What about the other arm?
Yes, both arms did.
Were the holes and frays large?
So immediately in redirect, what I thought was kind of a good point by Brennan, smashed by Jackson. The holes in the sweatshirt. It's like, oh, that was clearly from road rash and all over the sweatshirt. I wish they had pictures of it. I don't know if they showed them. I didn't see the pictures of it, but smashed by Jackson immediately.
Larger than the holes, the puncture holes that you saw on John O'Keefe's sweatshirt.
They were certainly larger and, again, spread out amongst the entirety of the sweatshirt, at least on the front side.
Was the damage to the sweatshirt that you saw in this experiment consistent with the damage or defects that you saw in just the right arm, those 9 puncture holes on the right arm of the sweatshirt of John O'Keefe?
No, this is distinctly road rash. There's a clear distinction between the two.
Looking at this particular set of defects in the arm, is that misleading in terms of its comparison to John O'Keefe's sweatshirt?
Sustain.
All right. So that was basically the portion of redirect. He does get into the fact that you don't work for an insurance company. They talk a little bit about the arm weight discussion, but I assume there's going to be a lot more come Monday on this redirect. I have to speak in about 45 minutes. That's when I'm doing my presentation here at the conference. So I'm going to hit some questions and then I'm going to have to take off. Danielle, thoughts on Hank Brennan going after Wolf's wife? I thought it was Bush League. This is not a fact witness that his wife has seen something and she's involved and she knows everybody in the case. He's an expert, should not have done it, in my opinion. Can this trial be used for a case on point in the future? Yeah, I think so. Not from the U.S. Is there a guideline budget to how much a case can cost the state? This seems more expensive than usual. Yeah, you'd think, but a lot of times they have unlimited budgets for these things. Sometimes you can go ask for more money in certain jurisdictions. If Dr. W has more images of Jumper, can he bring it? Unless it's directly related to Cross, probably not. Comparing ARCCA price tag to Aperture and the scope, does Aperture's $325K look like more like a bribe? I wouldn't say a bribe, but it looks like a waste of money. Still seeing the case as a battle of the experts? Well, yes, but I think the battle is being won by the defense experts. How do you expect Welcher to rebut this? I honestly don't know. I expected a lot more out of his initial testimony. I might have missed it, but did they x-ray his arm? Any x-rays of all 4 broken bones? I don't think they x-rayed his arm. I don't think, so they didn't confirm no breaks. Why didn't they take a hammer to a taillight to see that with the internal damage and that many number of pieces of glasses? Maybe it's a good question. I wonder if the judge would have allowed them to present that. That's a good question. When Bev says this time we'll get an answer, after AJ objects, asked and answered 5 times, could AJ strike Bev's comment? Seems inappropriate. If you're talking about Brennan, then yes, they could ask to strike that, not the judge's comment. Peter, is it possible the defense has a team scouring the internet, chat boards, and YouTube videos and still correct any confusion, but they have created with the witnesses? I think yes. I think they do, and I think they should. Was Brennan Whitey Bulger's lawyer? Yes. Peter, how self-aware is Hank Brennan about his behaviors? That's a good question. I think he's probably watching a lot of, stuff happening on social media as well. Some lawyers don't care. Some lawyers have been very successful with that demeanor, and they're just going to continue to go with what works for them. Peter, can John O'Keefe's family, father, mother, sue Karen Reed, it being a civil case, find her liable for his death? Example, O.J. Simpson? Yes. Have you noticed that Bev rarely says no more comments to Hank unless he rarely comments, did it once and got reprimanded? Hank repeatedly does it. She does not do that. She needs to, because he does it way too much. Difference between rebuttal witness and cross-examination. A rebuttal witness, they're going to call in a completely separate rebuttal case in chief. Cross is what the Commonwealth gets to do for every single defense witness. Brennan is relying on Welcher's notes on ARCCA, and it's showing how wrong and unrealistic Welcher is. Who has been a better witness for the Commonwealth, Wolf or Karen herself? I think Karen has been the best evidence for the Commonwealth with her interviews. I do not think Wolf has been a good witness for the Commonwealth. Peter, why would OJO's family bring a civil suit if she already has nothing left and they won't get anything out of her? Just wondering how that works. Well, they can get a judgment, and if she makes money in the future on a book deal or movie or something like that, they might be able to collect in the future. Tanya, the pig's DNA on the hoodie may be from a dog chewing pig ear treats. A bunch of people have said that, but they haven't brought that into evidence, so I don't know. No one has talked about that. Yeah, well, the defense has to bring that up if they want to argue it. I can't get the arm shattering the taillight out of my mind. Wolf's videos were a gift to the Commonwealth. Brennan can replay in closing. We'll see. Newsflash, state of Massachusetts hires Randy for $400,000. D-Rock, I hate to say it, but I thought Hank actually did pretty well at the end, all considering. He sort of found some holes, pun intended. Annoying ARCCA did not use the correct weight arm. I agree. That seems like an unforced error that you could have done easily. Does it make everything wrong? No, but it seemed like an unforced error. They didn't really need to. Peter, would you ever do a live trial? It's impossible for me to live stream all day. Were there grass stains on the hood? I remember them being on the pants, but I've been racking my brain about the hoodie. I don't remember, but it was also a much darker color. Peter, come on. How many homicide cases have you defended again? Just kidding. Just kidding. Yeah. People think I'm going to like resume compare with faceless Twitter trolls. Like, it's just not going to happen. I just decided to mess with them a little bit. Off topic. How's your criminal defense lawyers conference? It's fun. I got to run though here pretty quick. HB did say the Lexus clip JO in the head and knee. Yes, that's right. Because the bruise and then the damage to the head. Rebecca, it'll be my last for a while. Have a good conference, Peter. Thank you. Peter and I disagree on many things, but at least I am completely dismissed. I don't know what that means. Sorry, bad night in the ER. Or is she upset about something? I didn't mean to upset you about anything, Rebecca. If I did, I apologize. Maybe I'm just crappy. Have supper on me. I appreciate it. Hope your day gets better. The Warthog, will the defense get re-rebuttal with ARCCA? Unlikely, but me and my dad break this down more in the podcast, so check that out. Brennan reaching so hard, he has dislocated his shoulder. Brady, my lawyer, merch comes today. You're the best, fairest, most unbiased expert around. Easy on the eyes, too. Thank you, Brady. Hopefully you enjoy the merch. Off topic, but if the defense chooses to call Proctor last, in your opinion, is it a good strategy? I would not call him last. I would call the ARCCA guys last here because I know they're going to be good. I would have called Proctor in the middle just in case he didn't come off as good as I thought he would. Hank is not the coolest person I've ever seen, SMH. I tend to agree. There is a fake profile going around of his wife. Oh, that sucks. Last point, Peter. Why is the Commonwealth hiding the sweatshirt in glass case? I don't know. And I think the defense would have something to say about that if that was really an issue. How can the defense fight back with all the inappropriate comments by objecting and asking the judge to strike it and doing it professionally, which is what they are doing, but it sucks sometimes. Warrior, Dr. Russell was asked to match every abrasion to a specific tooth claw. Would like to see the defense ask the expert to match every abrasion with piece taillight. I agree, and I said this when Russell was on the stand. I agree. It would show just how dumb that question is. ARCCA video only helped the Commonwealth. Also, correct me if I'm wrong, but the jury does not know about Brian getting rid of his phone or the dog getting rehomed, right? I think they know they got rid of the dog, but definitely not Brian getting rid of his phone on a military base or the butt dials. Brennan is pretty bold for someone that witnesses said numbers don't matter and used cosplay and blue paint and with the educational issues. What's the deal with the multicam view? One channel has that pool feed. I'm not sure. No weight of JOK arm using 944 doesn't matter. I don't know if every jury will agree with that, but I think it was a good point to be made by Brennan. All right. That's all I got. I got to run, folks. Thanks for hanging with me. I hope everybody has a wonderful weekend. We'll be back at it tomorrow night with my dad. Make sure you're subscribed. Make sure you hit the reminder bell. Make sure you hit that like button. Love you guys. Peace out. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.